Video number 3 on the 10 biggest mistakes people make about the Baker Act. Number 3, believing that after 72 hours they're going to get released. I hear this all the time. They've been held 72 hours, they should be released. No. The 72 hours isn't the maximum, it's the minimum. Okay, and that's presuming that they're actually involuntary as opposed to voluntary. Well, what do you mean, Mark? Yeah, guess what? There's 2 types of Baker Act here in Florida. Involuntary and voluntary. And you may not know which one it is. Because if it's voluntary, and by the way, voluntary doesn't really mean voluntary, because if you're voluntary, you can't actually leave. What it really means is you're being held involuntarily for an indefinite period of time. No 72 hours. That's what it really means. But most of the time people get tricked into agreeing to stay voluntary, because if they really knew what it was, they'd never agree to it in the first place. So, involuntary versus voluntary. Involuntary involves a 72-hour clock, which only starts once the person's in a receiving facility or a receiving unit. So, if they went to the hospital first for medical care, guess what? That time doesn't count. Yeah, I've had it where people sat in the hospital, maybe the emergency room after an attempted suicide. 4, 5, 6 days. And then they get transferred. That time don't count. It doesn't count. Also, if the 72 hours expires on the weekend, guess what? The facility gets to keep you over the weekend, even if the 72 hours has expired. In fact, it rolls over until the next working day, which is typically Monday. So, by the way, when the facility tells you they can't release on the weekend, that's not true. They can. We get people out all the time on the weekend, but they're never going to tell you that. You're hearing it from here. They can release on the weekend if they want to, right? But they also know court doesn't open until Monday, so why should they release you? And by the way, they're an entity of the state, so you can't sue them for this anyway, so they don't care. Why shouldn't they just keep you? I mean, they're getting money for putting heads in beds. I mean, this is about business, people, for the most part. So no, you're not automatically getting out within 72 hours. That is simply not true. And the facility can file to keep you, right? And once they actually file, well, you could potentially sit there another 5 days because the court only has to conduct a hearing within 5 days. So just imagine this, right? You went to a hospital, spent a couple of days there. They transferred you. 72 hours for the initial assessment. They filed to keep you. That's another 5 days. And then they have a hearing. And at that hearing, they can ask for anything from 0 to 6 months. And if you think it can't happen, trust me, it can. I've had calls from the state hospital. I've had calls where people decided, well, we got it, it's only 72 hours. And the next thing they know, the judge enters an order for 2 weeks, 4 weeks, 6 weeks, 3 months. This stuff is not to be trifled with. Okay? If your loved one's Baker Acted, you need to take this really seriously, because your ability to make decisions for them, even if you are a healthcare proxy or a power of attorney, have been terminated. If you've got a healthcare proxy and a power of attorney, and your loved one's been Baker Acted, it's not worth the paper it's written on. Sorry to tell you that. You might as well throw it in the garbage. Unless, of course, you're willing to go into court and fight for those rights. That's a different story. That's where we come in. Otherwise, the facility is free to ignore it. They simply don't care. So, anyway, that's my 2 cents about the 72-hour rule. I'd be interested to hear what you think about it. Share your comments with me. Included in the description for this video is a link to our brand new book, all about the Marchman Act. You click on the link, you give us your name, your email address, and you can download it for free. It's 9 chapters, written video content. I made it for you so you can get information about Florida's awesome Marchman Act, which is a statute that allows us to put people into treatment for chunks of 90 days when there's a primary substance use disorder. So please download the book. If there's another issue that's you're dealing with in your family and I've not made a video, well, let me know. Post in the comments. I'll make you that video because I want you to have the information that you really need to get. Okay. If you like this content, please give me the thumbs up. Really helps with the Google algorithm. And if you want more of this content that I'm making for you every single day, and by the way, today's July the 3rd, the office is closed, but I'm making this content for you anyway, because I want you to get that information. If you want more of this content, subscribe to the channel. And with that said, thanks for tuning in. I'll see you in the next one. Bye-bye.